Hello and good evening to one and all. We are welcome back to Live Law Academy. We are here again with another relevant judgment, updating you with the laws. This is specific to negotiation, the NI Act. This is also very much relevant for you to understand that whether the Supreme Court's power to transfer cases, what cases will fall there, whether it has the jurisdiction to transfer a case related to section 138 of the NI Act. Okay, so this is the discussion that we are going to have today. Let me just share my screen with you. If you can see here, whether the NI Act section 138, if a complaint is filed for that, the Supreme Court has decided whether or not. I'll not be immediately telling you because we have written cannot here, but we'll be getting into the nuances of understanding why this cannot has been written. Okay. So section 138 NI Act, if any complaint has been filed, whether or not it can be transferred under section 406 of CRPC for lack of territorial jurisdiction. So if a particular case does not have jurisdiction only, can you reach to the court and ask them to transfer the case to another court which has territorial jurisdiction? The case here per se has to be a case of check bouncing, very lucidly that we use the term check bounce, but an offense under section 138 NI Act, and also to understand that where is the power mentioned and which court has this power. So here we are specifically talking about the Supreme Court's power to transfer, which is mentioned under section 406 of CRPC. All right, so this is the discussion that we are going to have. Now, again, just to quickly help you understand, we will be going through certain provisions in this discussion. One will be related to section 138 and 138 and 142 of the NI Act. Very important for us to read 142 because that lays down the procedure as to how the entire proceeding of an offense under section 138 has to be done. Secondly, we'll be talking about the scope of power that is present under section 406 of CRPC, the scope of power of the Supreme Court to transfer. Now, while I am going to conclude this for you, I would want you to take a moment and to answer in the chat box that do you remember anything from the Indian Constitution related to the Supreme Court's power to transfer a case from one court to another, from one high court to another high court? Is that something that we have in the Indian Constitution? If you know the answer, write it in the chat box. And how is that power similar, not similar? We can also understand, and you can do a mental comparison also. Okay, this is how you get more clarity. When you're preparing for an exam like judiciary, it will be very easy for you to remember provisions because there are so many sections that we have to remember, right? So one thing can be that you try to, when let's say I'm reading CRPC section 406, I try to recall that have I actually read something of this sort which is similar to this in the Indian Constitution? So we have a provision there, right? I'll be telling you about the provision. I am right now immediately not saying that because I want you to write in the chat box if you know the answer. Okay, so there is something from the Indian Constitution. What is that article? You can mention. Okay. Then we also, now again, another brownie point will be that you also try to recall where is Supreme Court mentioned, which part of the Indian Constitution, what are the different provisions from which Supreme Court starts, and the power, duties, roles, appointment of the Supreme Court ends, right? So you should know the structure also, which can be a question that can be asked in your preliminary examination. So this is primarily the context of today's discussion. In live law, in Live Law Academy, in our judicial services examination preparation course, we teach our students how to read judgment. We do a lot of discussion extensively, taking up their questions and helping them understand as to how do we read relevant judgments, because even if you read one judgment, it's going to help you in multiple manners. Some of those cases are something that we discuss here in addition to the recent updates that keep happening. So this is a case that has come this month only by the Supreme Court, decided by the Supreme Court, and because it is relevant for your judiciary exam, we are doing it here for you. All right, so I hope that you'll find this helpful. The name of the case is what we are going to understand. we have certain issues here. Okay, so I will be showing you three things. I will be showing you the provisions. I'll be showing you the copy of the original judgment. In addition to that, the document that I have prepared, wherein we have put the summary points, which will be important for you to remember the name of the case. Okay, so this is the citation that you can read from here, and this is the name of the case dealt by the Supreme Court very recently, getting into the question of whether the Supreme Court, if a petition is filed right now, if you see transfer petition, okay, so section 406 very clearly mentions that this proceeding has to be initiated by a motion, right? So here you will see that a transfer petition has been filed, and accordingly whether the transfer petition has been accepted or has not been accepted is what we will conclude with the case, right? So I hope you have understanding of the facts here. Now, what all has happened here per se related to this case is, let's delve into that. We have parties, right? So the petitioner here is this company which deals with oil and different set of oils and oil products, and we have Kotak Mahindra Bank, right? So there was a transaction of loan that took place between these two parties, where the petitioner actually took a loan from Kotak Bank. The petitioner works in a particular area, that is Coimbatore. Okay, I'll just run you from the judgment only. So the petitioner has his office in Coimbatore, has his industrial setup in Coimbatore. The petitioner has taken the loan amount, and his savings account is in Coimbatore. The transaction takes place in Coimbatore. In addition to that, the loan was also processed in the same branch of Coimbatore, right? So all of this has taken place in Coimbatore. But the check that was given by the petitioner to Kotak Bank was deposited in Chandigarh. Okay, so remember the chronology and remember the cities here. The presentation of the check to the bank has proceeded to Chandigarh. So even though all these different things that the working is happening in Coimbatore, the loan has been taken in Coimbatore and the branch is there, but the presentation of the check is happening in Chandigarh. And that is why when the check gets bounced because of insufficiency of funds, the Kotak Bank has initiated the criminal proceeding, 138 proceeding in the state in Chandigarh itself, right? So that is why the petitioner has now come to the court and says that this is causing me hardships, this is causing me inconvenience. Okay, try to understand that we are talking about hardship and convenience on the ground of language barrier, on the ground of discomfort in so much of traveling that will happen. And that is why the petitioner is asking the court to transfer the petition to the state of Tamil Nadu. Okay, so from Chandigarh, they are asking for the case to be transferred to Tamil Nadu. I hope the facts are clear now. Initially, I told you what are the different ideas, different laws that are relevant here for you to remember. Then I told you that what is the fact of the given case. Now, take a moment, take a pause, and try to think about it. Whatever you know from your CPC class, from your CRPC class, what do you think should happen as per common sense, as per your basic understanding of law? How this will help you is, you can also pause my video if you want. This will help you think and revise and recollect whatever you have studied already in your preparation or in your college, right? So this will help you recollect, and you will grow an opinion also as to what you think about this. And then why the court has decided something is that something that we are doing in this exercise, right? So the petitioner has tried to convince the court and highlighted all these facts that I've highlighted over here for you as well. The check was presented for collection and for payment alone, and the jurisdiction here should be of Coimbatore only. Okay, section 142 also is highlighted. We will talk about all of these provisions. Then the petitioner says that the headquarters are also in Mumbai, the branch office is in Coimbatore. Then where is this entire jurisdiction of Chandigarh coming from? And this has been merely done with an intention to harass the petitioner to travel all the way from Coimbatore to Chandigarh. Okay, so these are all the statements that have been made by the petitioner in the transfer petition filed by him. Now, the court has passed the order, but before getting into this, I will take you to the analysis part. What all are we going to discuss here, ma'am? So I'll just briefly summarize as to what are the headings that we are going to understand. Firstly, we will understand that what are the issues. You should have this habit of highlighting the issue, or at least tracing or finding out the issue in every judgment you read. Okay, this will help you understand, this will help you in your exam also. Framing of charges, framing of issues, all of this is a continuous exercise which you learn, right? So try to identify the issues while reading the judgment, while you're putting your effort and sweat in doing this. That is one way for you to work for your judiciary preparation also. Okay, so I will show you the issues that are here. Then we will see what are the arguments. I will not be going through one by one, but rather we will see that how the court has answered those arguments. Okay, so one is with regards to section 406, what is the scope of it. Okay, then we will also understand that how does transfer really happens. We will see that what happens when there is a civil case, how is it different from a criminal case, and where is the where does the power really and actually lie. Then we will see that what is the idea of section 142 of the NI Act. Okay, and we will try to understand that when the amendments were made in section 142 section 2, what was the idea of these amendments, what has motivated the court to put this amendment, and does it really restrict the jurisdiction of the court or not. Okay, so where all can the jurisdiction lie has been mentioned in 142. So we get something from there, and then we try to understand that what should happen in this given case. All right, and yeah, I think more or less these are the points that are covered in this case. Now, before we proceed with the issues, let me just quickly take you through section 138 and 142. Right now, we are not getting too much into the depth or the analysis of section 138. Keeping it short here, you can just refer to the title that there's this we have chapter 17 of the NI Act, which specifically talks about section 138, that is dishonor of check if there is insufficiency, and then there are requirements, right? These requirements are very important for you to know for your exam perspective. So it may look like a lengthy provision, but break it down into important parts. And today only you do this exercise, that you at least for once go through section 138. Okay, highlight 6 months, highlight 15 days, highlight these points. These are important for you to remember. All right, so whatever time period is mentioned here, just highlight it for yourself. I'll be going to section 142 because that is the discussion that is relevant for this case. Okay, so section 142 starts with a non obstante clause. Now, what is the relevance of this non obstante clause? We'll discuss, but let's see what is this talking about. It says, notwithstanding anything contained in CRPC. So this law, that is NI Act, is giving you a certain procedure related to the offense committed under section 138, and it very specifically lays down the procedure and also says that notwithstanding anything contained in CRPC. So CRPC section 406 gets excluded, or the Supreme Court still enjoys the power to transfer cases or not. Okay, that is one thing. That is a question that should come to your mind when you're reading this non obstante clause, which very clearly specifically says notwithstanding anything contained in CRPC. So let me switch to English also now, okay, for other students to understand. this ये सेक्शन जो है 142 ये स्टार्ट हो रहा है एक नॉन ऑब्स्टेंटे क्लॉज के साथ, जो बोल रहा है नॉट विथ स्टैंडिंग एनीथिंग इन सीआरपीसी, और सीआरपीसी की ही डिस्कशन हम कर रहे हैं, विच इज सेक्शन 406. सेक्शन 406 किसके बारे में बात करता है? सुप्रीम कोर्ट के पास पावर है ट्रांसफर करने की. ओके, किस किस केसेस को ट्रांसफर करने की, कौन से कोर्ट से कहां वो ट्रांसफर कर सकता है, क्या वो सुओ मोटो ट्रांसफर कर सकता है, क्या पार्टी को अप्लाई करना पड़ेगा, क्या एजीआई अप्लाई कर सकता है. ये डिस्कशंस हैं जो अभी हम कवर करेंगे. ओके, सो यहाँ हमने फर्स्ट पॉइंट पढ़ा, फर्स्ट क्वेश्चन हमारे माइंड में आ गया और हम इसका आंसर ग्रेजुअली फाइंड आउट करेंगे. दूसरा पॉइंट हमारे लिए इंपॉर्टेंट है, वो है दैट द amendment that was made. Okay, so if you see, Proviso that is so mentioned here has been added later, that is once in 2002, and then this entire subsection 2 has been added by the Amendment Act in 2015. So 2015 is an important point. आपके एग्जाम में एनआई एक्ट पूछा जाता है, आपके एग्जाम में सीआरपीसी पूछा जाता है, आपको एज अ लॉ स्टूडेंट सुप्रीम कोर्ट के डिफरेंट पावर्स पता होनी चाहिए. तो ये एक इंपॉर्टेंट टॉपिक है आपको समझने के लिए, राइट? सो वैसे ही यहाँ पर लिखा हुआ है, the offense under section 138 shall be inquired into and shall be tried only, okay, inquiry and trial, so only by a court within whose local jurisdiction, if the check is delivered for collection through an account for collection, which has happened in our case. Okay, so A is something which is relevant for our case. If the check is delivered for collection through an account, the branch of the bank where the payee or holder in due course maintains the account is situated. Okay, so what are we basically talking about? किसको यहाँ पर कौन है हमारे situation में holder या payee? That is Kotak Bank, right? So where is when the check has been delivered for collection, where is the branch of bank where the payee or holder maintains the account? Us situation में, if they hold an account in Chandigarh, will Chandigarh be the right place, or will it have the right jurisdiction to entertain the case or not, right? So this is very clearly put here under section 142 subsection 2. If this is a situation where check is delivered for collection, you understand that where you can invoke the jurisdiction in such a situation. Now, generally when we study CPC, we understand jurisdiction has multiple things that we have to see. Where is the defendant residing, where is the place of business, where the cause of action arose, different cause of actions are there. So all of these things are out of picture now because we have already read section 142 too. Okay, but still we will discuss in context of the judgment as to how the court has answered each one by one. So the issues before the court were three. These following three issues that were highlighted before the court. First, whether a complaint filed under section 138 can be ordered to be transferred from one court to other in exercise of power under section 406 on the ground of lack of territorial jurisdiction. Okay, you have already seen the title of my video and therefore you understand that it should not be allowed. But what is the reasoning? Why did the court say that for lack of territorial jurisdiction, maybe the power under section 406 will not be as relevant? Okay. Secondly, assuming that the court in which complaint has been filed lacks territorial jurisdiction, then is it permissible for the court in exercise of power of 406 to transfer? If it is so seen that it actually lacks jurisdiction, will it be okay for them to transfer the case to other court which has jurisdiction? And the last point here is whether the expression for the ends of justice in section 406 embraces in itself the lack of territorial jurisdiction of the court to try the offences under section 138. I understand. आपको third issue नहीं समझ आया होगा. I can totally understand. I will show you section 406 and the language used in 406 for you to get an idea as to whether this is right or not. Okay. So this is how section 406 is mentioned. Whenever it is made to appear to the Supreme Court, okay, it is made to appear, okay, and now later you will see also this section is can be invoked only on the application by Attorney General or partly or any party interested only, right? So can it be suo motu? No. It is made to appear to the Supreme Court. Now, the provision that I was talking about was Article 139A of Indian Constitution. If you have not read this, you must now only with this topic read that also, so that you can do a comparative analysis and understand that what is really different there. What was the need of introducing Article 139A in the Indian Constitution? Is it anyway similar to 406? Is it different from 406? You will get an idea about it. Okay. So here, whenever it is made to appear to the Supreme Court that an order under this section is expedient for the ends of justice. This is a very important part, right? We are saying that the Supreme Court exercising its authority under section 406 when it feels that it is required, it is expedient for the ends of justice. It may direct any particular case appeal to be transferred from one high court to another high court, or from a criminal court subordinate to one high court to another criminal court of equal superior jurisdiction subordinate to another high court. Okay, these are points which are very, very, very important for your preliminary examination. So wherever I have put extra emphasis, if I have highlighted these points, you have to remember when you're comparing it with 139A, see which court is that talking about and which court is section 406 covering, and that comparison will help you always remember the distinction and to put the right answer in your preliminary exam. Okay, and then the court can also dismiss if it finds that the petition was frivolous or vexatious. And very important, another part is that it has to, and every such application shall be made by motion. Okay, so that is why you see a transfer petition being filed in this case. So this is the summary of section 406. What all did we understand from it? That if a party feels that there is, that there must be a transfer of case from one court to another, which court we have discussed, then it can apply to the Supreme Court for the transfer to be done. The Supreme Court can do so, okay, provided that it feels that it will be required for expedient disposal and for, at the same time, for the ends of justice. Now, this is an important aspect. This is also granting discretionary power to the court. Now, that is what the court is exercising in this case, right? The court has decided whether in this case of section 138, where it lacks jurisdiction, it should be disposed of or not, it should be transferred or not. So that is why discretionary power also is given to the court here. And that discretionary power takes us to the concept of equity, which you must know. Okay, so I'm not getting into the discussion of equity, but it is important and it is relevant. Those who know, they must would have immediately understood the nexus between the two, and those who do not know, they must know it if you are preparing for judiciary. Okay, so these are different issues, and these are the different provisions, section 138, 142, 406 that we have understood so far. All right, now I will immediately take you to section 142 that we already studied. Now let's just try to understand. The first question was, is it excluding CRPC? If it excludes CRPC, then does it exclude 406 also? If yes, then there's nothing for the court to answer, right? So that is the first thing that we have to understand. All right. So the court has said, firstly, that while discussing the concept of section 142.2, what did 142.2 talk about? Yes. Section 142.2 spoke about that if this is a case wherein you have received the check, where are you applying for the check is important. Okay, wherever the payee has or the holder has the account, that place can become the authority for us to see the jurisdiction. Okay, so wherever the payee or the holder maintains the account, if this is delivered by collection, and that is what has happened here. Now the court takes us through different precedents. All right, I'll just give you a summary of these precedents. You can omit to remember this case, that is Yogesh Upadhyay, but if possible, write two cases from here. One is this case of Yogesh Upadhyay, okay, and the second case will be of K. Bhaskaran. This is very important. This is 1999, okay. I highlight points in my judgment wherever I feel I have to address this point to my students, okay. Likewise, when you're reading your judgment, if you have time, highlight those points which are helpful for you. So this is back in 1999 when the court addressed that there are 5 components by which, section 138 comes into picture. An offense comes into picture which is mentioned under section 138 when these 5 components are fulfilled. First is drawing of the check, second is presentation of the check, returning of the check, giving notice related to demanding the payment for the check, and the failure of the drawer to make the These are 5 instances. Wherever these 5 things are happening, all those 5 different areas will have jurisdiction. What did I say? In 1999, the court decided that there will be 5 jurisdictions. If these 5 steps have taken place in 5 different places, all the 5 different places will have jurisdiction. But did it continue for too long? No. So very, very important case for you here is this. Dashrath Roop Singh Rathod versus State of Maharashtra. This happened in 2014 and an amendment took place in 2015. So to confirm what has been held by the court in 2014, we have now made changes in 142, and 2015 amendment is a depiction of this judgment. That is why this judgment is important. If you're preparing your notes for 142, you have to always remember the name of this court. Okay, so this case basically very specifically said the same thing which you have read right now, that the 5 locations are restricted now, and it said here, the court said here, that it will be restricted to where the drawee bank is located. Okay, such that where the check has been dishonored. So basically we have narrowed and restricted it to, let's say if I have given a check to you, the check gets bounced because of insufficient amount. Where did it bounce from? Where did it get dishonored from? That place becomes the place where the jurisdiction lies. And in our case, we have studied the facts. In our case, in this given case, the dishonoring of the check happened in Chandigarh only. So Kotak Bank has, tried to convince the court here by their arguments that we have followed what has been held in the judgment. We are following what has been stated in 142 and we have not gone against the law. Okay, so that is first idea. Okay. Then this is a discussion that I've already told you here. The court has said, repeating or referring to the statement of object and reason whenever there's amendment, you can, to understand why the amendment has been made, you can refer to the statement of object and reason. Okay, so this is interpretation, external aid by which the court has tried to help the party understand that how 142 was introduced, how it was affirmed later in 2016, and how it has continued. So choosing Chandigarh is a rightful choice that they have done here. All right. So this is how we conclude the first point. Okay. Then coming to the point as to, does the non-obstante clause override section 406? So in the same case, the court clarified the relevance of non-obstante clause. The court said that if you see, even before the amendment of 2015, the non-obstante clause has always been there in the NI Act. And it has been there because it merely tries to recognize that there is a different procedure which is to be followed for 140, 138, for the offense of 138, which is mentioned in 142. And how is it different? So they have given an example that even though, let's say, how does this offense become different? So if you read this, it is different, or it has a departure from the usual procedure, because here from the prosecution, as the said offense stands postponed despite the commission of the offense. So even though the commission of offense happens, dishonoring of the check has happened, you still give a notice to the party, right? And the window is still open. So the prosecution is delayed, and that is why, because it is special in nature, there is a special procedure so mentioned under the law. And that is the reason of having the non-obstante clause. Okay, so you holistically read it, you will understand that by the literal reading of it, the non-obstante clause does not exclude the Supreme Court from exercising its power under 406. The High Court also has a power to transfer, that is under 407, but it is a little different. It is a more descriptive provision which lays down the grounds very clearly as to when can the High Court really make the transfer. Okay, so you can refer to 407 also for your understanding. You do not have to postpone things. If you have to be judges, you have to be very, firm. You have to immediately read things, try to understand, and then accordingly get done with those topics. All right. Okay, so we have understood first part of 142, that it was introduced because of a reason. We understood the non-obstante clause and its relevance also. Now we come to section 406. I've already read 406 with you. I have highlighted the relevant portion here. Expedient for the end of justice, because this is something which will vary from case to case. This is something which will need elaboration. It becomes important for us to, for the courts to see from case to case basis as to how it has to be interpreted. All right. So in one of these cases back in 2020, the court said that transfer is mostly sought on two grounds. One is lack of territorial jurisdiction, which we are seeing here also. And the second is apprehension of bias. So there are 5 grounds which have been mentioned. See, what all decisions can the Supreme Court take to further justice, to expedite justice? So there are certain grounds that have been laid down by which the court has tried to convince that if you see any of this is there, you can definitely immediately transfer the case from one court to another. But other than that, whether in a given situation, for lack of jurisdiction, the transfer will be allowed or not is something that we have to still see and still decide. And that is what has been decided in this case. Okay, I'll show you those 5 points from here itself. Yes. So para 49, okay, of this case gives us these five grounds, yes, gives us these 5 grounds which have been given in this particular precedent. Okay, what are these 5 grounds? If I have to summarize and say, these 5 grounds basically talk about those situations where even you will feel merely by reading it that the Supreme Court must interfere. Do you think in a situation where there is apprehension that the witnesses may turn hostile, that the witnesses may get affected, they may get influenced, there's a lot of communal surcharge, okay, because it is such an issue, there is a possibility that it will be impossible with time for us to prove a case, fair and impartial trial will happen, okay, comparison of inconvenience. So it should not be mere inconvenience, but it should be comparative inconvenience happening to all the parties, in addition to simply talking about the expenses to be incurred by the state. Okay, so inconvenience, while inconvenience may not be a ground, but comparative inconvenience can be one of the ground to be considered by the court to entertain a case under 406. Then if in a situation there is material to show that the accused may influence the prosecution witnesses, if there is a possibility or if it appears that the state machinery or the prosecution is acting hand in glove, right? So if there is a possibility of biasness, miscarriage of justice, in all those situations, we clearly have seen these grounds being laid down in a precedent wherein the courts have highlighted section 406 can be invoked. But it does not cover the concept of territorial jurisdiction. If lack of territorial jurisdiction is there, can the court really transfer or not? Okay, so that is our discussion that is still left because it has not been answered in these precedent. Okay, I also scroll through a lot of relevant points, so I'll just immediately tell you that as well. Basically, in that part of the judgment, they are talking about section 406 and the power related to it. Because we understand we have section 21 in CPC, we understand that we already have procedure under CPC wherein we allow a window for the parties to seek transfer, for a party to go to the another court with relevant jurisdiction. This may not be so available in the case of CRPC, right? CRPC, even if there is transfer mentioned, it is very restrictive in nature. It has certain if buts and cons, right, wherein it says that it will only be for a complaint case, not for when we have a police report. It will not happen after the entire investigation has been done. So there are a lot of if and buts that we already see is there when you're talking about a transfer in case of a criminal case, right, when the court lacks jurisdiction. So that is one part that is so there that we have missed on. Secondly, the discretionary power that I spoke about, the judges have tried to answer that also, and they have said that the discretionary power is very wide and therefore it has to be applied and it has to be used in a very restrictive manner for ends of justice only. When it appears that the power is very much required, then only you use the power given under section 406. Okay, so keep these points in mind. Whatever I have told you, firstly, section 406, you try to see that how the civil code and criminal codes actually, actually revert to a case where the court in which you have initiated the proceeding lacks jurisdiction. How is it different? If the window is narrower in criminal code, then what power and what should be the extent of power under section 406 in that situation? Okay, and then to summarize all of this, we can read this paragraph wherein it says that although there is no rigid and inflexible rule or test laid down for the power of 406, okay, but it is very much clear from the bare reading that this power has to not be applied as a matter of routine. Okay, so order of transfer should not be applied or should not be passed as a matter of routine, and particularly rather it should be applied in exceptional situations. Okay, and specifically speaking about this, the court in this case has said that we have to be hesitant when we are dealing with a case of the lack of territorial jurisdiction. So that is why the heading that I have given here is coming from this paragraph number 49 of the judgment, wherein the courts have highlighted, after assessing, after addressing both the parties' argument, the court comes to the conclusion that yes, 406 is a wide power. We understand and acknowledge that it has been given for dispensation of justice. That again leaves the court a vast set of powers, but it should be hesitant. It should be applied in exceptional situations only. All right, and I have given you certain exceptional situations which does not include lack of territorial jurisdiction in the case. All right, so this is more or less the summary that we can take up from the judgment. There are a lot of relevant other things also, which we do not have time, or which may not be very, very relevant for your exam. But if you are preparing for yourself, if you think that you have to know the law and you should know in and out about this concept, that I would request you, this is not a very lengthy judgment, 89 pages, you can definitely cover 89 pages and do that. All right, more or less we have already covered. You can let go of the argument part. Okay, now coming back to the given case, the court then addresses at the end that here the collection of the check was done at Chandigarh, and therefore the court is absolutely fine. Chandigarh has jurisdiction and it can accordingly definitely go ahead with the case. And then the court says that even if in a given situation we say that Chandigarh does not have the jurisdiction, then in that case also, merely on the ground of hardship or merely on the ground of inconvenience, it will not be right for us to transfer the case from one court to another. So it is something, it must not be something that you're alleging, it must be something that is actually in existence, which must be visible to the court for them to take this action. All right, so this is the judgment by which we can now conclude, and by which we can now understand that in a sense you can understand and you can conclude that section 406 is wide set of power. Can in a given situation territorial jurisdiction be questioned? If yes, if it can be definitely questioned here, but at the same time we do not find any precedent for the same. So unless and until you have a precedent, do not say yes for it. Okay, secondly, we are saying that at the same time we are understanding here it was rightfully put at the same place, Chandigarh, which was as per section 142, and therefore the parties were right. But the court says that let's say Chandigarh did not have jurisdiction, then on the ground of mere inconvenience we would have anyway not transferred your case from one place to another. Okay, there has to be those 5 grounds which we have highlighted, either of those or something more convincing for the court to invoke the power mentioned under section 406 of CRPC for them to actually refer to this power and for them to give remedy to the parties. All right, so I hope this has been helpful for you. If you have any doubts, you can leave it in the chat box. If you have any feedback, you want us to cover anything for you, you can definitely leave your suggestions also in the feedback. I will very quickly revise and repeat the summary of the entire discussion. If you've stayed so far with me, definitely you deserve the summary. We understood and we started with section 138 and section 142.2. We tried to understand the idea of introducing section 142. From 5 grounds, we saw that we have a restrictive set of ground that was mentioned and recognized by judgments itself, the Dashrath case, okay? And therefore, this was codified and this was reflective in the amendment introduced by 2015. Similar to this, we were studying parallelly CRPC section 406. I have told you that for your homework, for your better understanding, you can do a comparison of section 407 CRPC, article 139A of Indian Constitution. These two are related to power of Supreme Court. This is related to power of High Court. Okay, and accordingly, you will get a better understanding on this concept. With this, I will stop now and I'll see you in another video with another important relevant judgment. Thank you, all of you.